Welcome back to the deep dive. For months, maybe even years now, we've all been kind of consumed by the messy headlines about AI and creativity.
Absolutely. The lawsuits, the arguments about fair use.
Who owns the image? Who wrote the text? But today, we're going to try and look past all that litigation right into a problem that is, well, far more fundamental. We're staring right into what our primary source material for this deep dive calls an ontological crisis for the law itself.
That is exactly the right term for it. I mean, the legal categories we've used for, centuries to protect human creativity, copyright, patents, you name it, they're conceptually just collapsing when they collide with the generative mechanics of large language models, LLMs.
So it's not just a tech problem we can fix with a new rule.
No, not at all. It's a foundational breakdown of what we even believe constitutes a creative work in the first place.
The core contention here, and this is really the hook, it's surprising. Traditional intellectual property, or IP, it assumes three things have to exist. A work is fixed, an author intends it, and originality can be attributed to someone. Our deep dive today, which is drawing from this really radical paper analyzing the deep learning geometry of LLMs, argues that generative AI, it invalidates every single one of those assumptions. All at once.
It really is a radical first principles framework, and that's the key. We have to move away from these, superficial debates that try to fit AI into existing human roles.
Like, is it a tool? Is it a ghostwriter? A collaborator?
Exactly. Yeah. Instead, our mission today is to understand the underlying technical reality. I mean, how these things actually work, how they sample from something called latent space, and what specific revolutionary IP doctrines must logically emerge from that reality.
And the aha moment we're aiming for, the real shift in perspective we want to get to is this. We need to start viewing AI outputs as fixed works or artifacts, like a printed photograph.
Right.
And start viewing them as events and trajectories, more like a constantly shifting kaleidoscope. And that fundamentally changes the object that the law is supposed to regulate.
You've hit it right on the head. Current law is trying to apply property deeds to a cloud formation. It's trying to regulate a fixed two-dimensional document when the actual phenomenon is this probabilistic manifestation in a high-dimensional space.
That mismatch.
That mismatch is the source of all the legal incoherence we're seeing play out in courtrooms all over the world right now.
Okay, let's unpack this, starting with this structural collapse.
So the foundational problem, it really lies in the very nature of IP law itself. You have to remember, it was conceived during, the printing press era.
Right, for physical objects.
It was optimized for human agency. It's centered on this idea of a conscious agent making deliberate choices and then fixing those choices into a tangible medium, ink on paper, notes on a musical score.
And the moment LLMs arrive on the scene,
the structure of that foundation becomes, utterly irrelevant.
You call this the ontological crisis. The very nature of the thing's existence is being challenged. Can we break down those 5 foundational assumptions that the source material says are failing? What are they? And why do they break so completely?
Yeah, let's run through them. It's useful to do it sequentially because you can see how AI breaks IP law at every single logical step.
Sure.
First, and this is maybe the most critical one for copyright, it's authorial intent.
The cornerstone.
It is the cornerstone of creative protection. The idea that a human author intends to create something. They have a mental state that supports their claim of originality. AI, however...
it has none of that.
None of it. LLMs are mathematical functions. They lack consciousness. They lack mental states. And they certainly lack the kind of intention that's required to be deemed a legal author under our current regimes. Any purpose we see, like if we tell it write a poem about sadness, is purely statistical prediction.
Okay, but let me push back on that a little. What if I write a highly specific prompt? Something like, write a haiku about a lonely astronaut floating past Jupiter in the style of Edgar Allan Poe. Doesn't my intent transfer over? Isn't my prompt the creative input?
That's the intuitive argument. But the source material argues pretty convincingly that the prompt is merely a conditional trigger for the statistical process. Your intent is absolutely real, but the machine's execution, it lacks a corresponding intent.
So the machine isn't trying to be Poe?
Not at all. It is optimizing the likelihood of generating a sequence of tokens that statistically resembles Poe, given the surrounding text and the context of your prompt.
Yeah.
The legal focus has to shift from the intent of the person writing the prompt to the stochastic, the random nature of the outcome generator, which has no intention at all.
Okay, so that's failure number one. Authorial intent is gone. Failure number two, you said, relates to the requirement of fixation.
Right. Traditional law requires a work to be fixed in a tangible medium of expression.
A finished sculpture, a master recording of a song, something you can point to.
Exactly. But according to the deep analysis in our source material, no AI output is truly fixed in that traditional sense.
And this is because of the probabilistic nature of the model.
Right, precisely. A generative AI doesn't just stamp out identical copies like a printing press. Every single prompt, every tiny variation in a setting like temperature or randomness, it yields infinite, subtly different variations.
So the output isn't a fixed thing, it's a sample.
It's a probabilistic sample, a momentary manifestation. It's not a fixed artifact designed to be reproduced identically. If you put in the exact same prompt a second time, you will get another distinct probabilistic sample. They might look 99% similar, but they're not the same.
It's like comparing two snowflakes. They might look identical to the naked eye, but mathematically, geometrically, they are distinct. The law, though, is built to regulate the stamp, not the snowflake.
That is a perfect analogy. That's the mismatch. And this lack of fixation, it leads directly to the third failure, causal traceability.
Attribution. Who's responsible? Where did the creative input come from when an output gets challenged in court?
That's the legal question, but the technical reality is the blocker here. These models operate using what are called nonlinear parameter cascades. We're talking about billions, sometimes hundreds of billions, of parameters interacting all at once.
Which means?
It means that linear attribution tracking the creation cleanly from one source input through a specific pathway of parameters to the final output is, for all practical purposes, impossible.
Can you break down the scale of that nonlinearity for us? What does that really mean for trying to trace attribution?
Sure. Think about it this way. In a traditional creative work, if a human author copies a sentence from a book, you can trace that sentence right back to the original text. It's a straight line.
A to B.
A to B. In a massive LLM, to generate a single sentence, the input token travels through maybe 96 different layers of transformers. In each layer, it interacts simultaneously with every one of the, say, 175 billion other variables, modifying its trajectory based on learned statistical weights.
So the final sentence isn't just A plus B.
Not even close. It's the product of A, B, and C interacting with 175 billion other variables in a completely nonlinear fashion to produce D. The causal chain it dissolves into a probabilistic fog.
So the human legal system wants a clear receipt showing that A bought B, but the AI just shows us a massive chemical reaction where all the original ingredients dissolved into some new substance.
That's exactly it, which brings us to the fourth failure, human originality. LLMs simply do not originate in the human sense of the word. There's no inspiration, no deliberate design. They function by recombining what are called latent vectors. These are the stored concepts and relationships and linguistic interactions that have been shaped by trillions of training data points. The output is a high-dimensional synthesis. It's a statistical derivative, not a moment of human inspiration that meets the legal standard of originality.
So if originality is defined by that spark of independent human creation, the AI is just demonstrating an incredible mastery of learned patterns, not a spark.
Precisely. It's demonstrating statistical perfection in synthesis, which is a different thing entirely. And finally, that leads to the fifth failure, ownership.
It's as if all the other pieces are gone.
Exactly. If there's no intent and no originality in the human sense, the source argues there is no coherent legal subject, not the human, not the machine agent, that produces the output in a way that you can assign ownership to. You can't assign ownership if you can't coherently locate a source of authorship that meets the legal threshold.
This is a devastating list. If all 5 cornerstones of IP law are collapsing at the same time, this isn't just a legal challenge, it's a massive societal pivot.
It is.
And this structural collapse forces that key conceptual distinction you mentioned earlier, the difference between regulating fixed artifacts and regulating dynamic events.
Yes. Traditional law, it attempts to regulate a fixed artifact, the final print of a book, the completed blueprint for a building. LLMs, however, they produce events which are probabilistic, often non-repeatable, and temporary manifestations of the underlying algorithmic topology.
Okay, that word topology. It's a bit heavy on the jargon. Can we unpack algorithmic topology for the listener? What does that actually mean?
Absolutely. Think of the topology as the unique, specific, high-dimensional map that the AI has built in its mind based on all its training data.
So it's the structure of its knowledge.
It's the intricate structure of connections, the specific geometry of that latent space we mentioned. It is the accumulated knowledge structure itself. What's fascinating here is that the law is trying to fit that dynamic, high-dimensional knowledge map into a flat, two-dimensional category, a fixed document. It's conceptually impossible without a new framework. We need a sui generis, a unique IP paradigm.
So we have a collapsing foundation. If legal scholars and courts, they can't just ignore this problem, what have they been trying to do to fix it? Our source material points to two dominant but ultimately failing strategies that are being used in all these legal debates right now. I imagine they're tempting because they offer a simple answer.
Oh, they're very tempting. They rely on analogies, which is what lawyers are trained to do. But both of these dominant strategies are fundamentally flawed because they're trying to force the square peg of AI mechanics into the round hole of human-centered IP law.
What's the first major error that scholars are making as they grapple with this crisis?
That would be strategy one, the retrofitting approach. This is by far the most common response we see from IP lawyers today.
Yeah.
It's the attempt to just stretch the existing copyright concepts, authorship, fixation, originality, to cover AI outputs.
So lawyers are arguing things like, well, the human who wrote the prompt exercised control, so they're the author.
Right, or the final digital file saved on the server is fixed, so it meets the fixation requirement. They're trying to find familiar legal hooks.
But I mean, if the output looks like a fixed book, doesn't the law have a duty to treat it like one, regardless of the internal physics? How do you convince a judge that the underlying mechanics are all that really matters?
And that's the friction point. The source material argues that this retrofitting approach, it just collapses into conceptual contradiction because it incorrectly assumes that AI outputs are works created by an author. By trying to retrofit, you're focusing only on the surface appearance, that two-dimensional document, and you're completely ignoring the core, probabilistic and non-intentional nature of the production process. You're fighting against the technical reality of the model itself.
So we're applying rules that were meant for deliberate, human-controlled manufacturing to what is essentially a stochastic, automated geological process. It's an unsustainable legal fiction.
Precisely. If we accept that the AI's output is a probabilistic event, then the concept of authorship derived from a prompt is tenuous at best. The prompt merely biases the probability distribution. It doesn't cause the specific output in a legally meaningful way.
Okay, so that's retrofitting. Now let's look at strategy two, the anthropomorphic approach. This is the one that gets a lot of media play, the idea of granting AI legal personhood or rights.
Yes. This approach tries to solve the missing author problem by just treating the AI as a putative creative agent that's entitled to some form of legal recognition or status, maybe something analogous to a corporation or an inventor.
It has a certain, futuristic appeal. Why not just grant the AI rights, solve the ownership dilemma that way, and move on?
Because it fatally collapses the moment you examine the AI's internal state. This approach fails because AI lacks intent. It lacks mental states, and it lacks autonomy in any, what the paper calls, epistemically relevant senses.
In plain terms, what does that mean?
It means it doesn't know that it knows, and it can't choose its actions in the way a human can.
A statistical illusion, as the source material puts it.
It's a powerful phrase, isn't it? Any apparent agency that we perceive, the machine writing a convincing love letter or solving a complex puzzle, is merely a statistical illusion emerging from parameter ensembles. It's an expert pattern matcher, not a conscious decision maker.
And the consequence of using that illusion as a legal basis, what's the harm?
Anthropomorphizing the system, treating it like a person, it does tremendous damage because it obscures the underlying mathematical mechanics. If you start granting rights based on an illusion, you distract the law from the real subject. The algorithmic structure itself, which is where the intellectual labor, the training, and the actual value reside, it produces deep, deep doctrinal incoherence.
So both of the dominant strategies fail. Retrofitting ignores the technical physics of the AI, and anthropomorphizing ignores the philosophical reality of the AI. They fail because they start from analogy.
And that's why the proposed starting point in this source material is so vital. It says, stop asking, how can we fit AI into human-centered IP law?
And start asking,
what kind of intellectual property framework emerges when we begin from the actual generative mechanics of LLMs? That shift from analogy to first principles is the only way to build a coherent, durable legal system for this new world.
This is where we get into the really constructive part of the paper. We move into the conceptual architecture. It's a lot of new material, but the premise is just so compelling. Deriving legal categories directly from the technical architecture of the LLMs themselves.
From the probabilistic sampling, the latent geometry, the parameter aggregation.
Right. And these five emergent theories, they entirely shift the legal focus. It's not about the human author and the fixed output anymore. It's about the underlying algorithmic topology.
They are designed specifically to regulate events and trajectories, not artifacts.
Let's dedicate some time here to really define and illustrate these, starting with theory one, probabilistic composition rights, or PCR.
PCR directly addresses the failure of fixation and originality we talked about. If an output is defined by its path, its trajectory through a massive probability space, then the rights must be based on the likelihood and the structure of that output as a statistical sample.
Okay, so the legal question dramatically shifts. How does it change in practice?
Well, instead of asking, is this a literal copy of the text or the image, which is the current copyright standard,
The one we use now.
the one we use now, we would instead ask, is the statistical probability of generating this specific output trajectory unduly high or structurally manipulated? The work is legally defined by its unique trajectory in that probability space, not its final form.
Give me a concrete example. Let's say a new AI model is released, and users realize it can generate a novel that is, 90% statistically similar to a famous copyrighted novel, even though the words aren't an exact match. PCR would regulate the likelihood of that happening.
Precisely. It's regulating the propensity of the algorithm to generate that statistical outcome, not just the final text itself. If the model is found to be too biased toward a protected trajectory, PCR allows the rights holder to intervene at the algorithmic level to adjust that bias, rather than having to sue over every single individual output that gets generated.
That makes a lot more sense. Which brings us to theory two, latent space rights, or LSR. This is the idea that infringement can happen invisibly inside the machine.
Yes. Latent space, again, is that high-dimensional conceptual area where the model stores and connects relationships between data. It's where the concepts, the styles, the meanings, where they all live.
So LSR.
LSR proposes ownership or control over specific proprietary latent structures or clusters within the model's internal geometry.
This feels like owning an idea itself, or a style, which a traditional copyright law explicitly prohibits. That's a huge shift.
It is a radical departure, but a necessary one, given the mechanics. When a model learns a specific proprietary visual style, say the unique shading and texture used by a famous graphic novelist, that style is encoded as a measurable, high-dimensional pattern of connections in its latent space.
So infringement isn't about the final image you see on the screen. It's about the presence of that proprietary structural geometry inside the machine that allows that image to be generated in the first place.
That's the core insight. Reproduction or similarity is defined not by surface expression, the words or the colors of the final product, but by latent space replication. If you copy the structural geometry of a protected style or concept within the latent space, that is the infringement. This provides a legal hook for all those cases where models are clearly synthesizing protected styles without literally copying any single fixed work.
Here's where it gets really interesting. Because they're not just changing the rules, they are changing the objects we are regulating. We're moving the focus from the surface to the structure. Let's move to theory three. Constitutive parameter rights, or CPR.
CPR gets at the sheer effort required to train these massive systems. It focuses the rights on the actual mathematical parameters, the billions of weights and biases that constitute the model's knowledge base, its topology.
Why regulate the parameters themselves? Why go that deep?
Because the training process is the core intellectual contribution. If these LLMs are defined by their topology, then authorship must reside at that parameter level. It recognizes that this topology was shaped by trillions of linguistic interactions with the training data. This focuses the IP right on the effort of training the massive knowledge base, which is an enormous investment of capital and compute power.
So if a rival company tries to build a derivative model by using a method called distillation to essentially clone the weights and biases of a highly successful protected model, they would be infringing CPR even if their training method was slightly different.
Exactly. Or if a malicious actor just copies a model's parameters or even replicates a high percentage of the essential parameters, they're infringing CPR because they're replicating the core intellectual contribution, that unique knowledge structure that took immense labor to forge.
Okay, next up is theory four, nonlinear attribution theory, or NAT. This takes on that traceability problem, what you called the probabilistic fog.
Right. NAT is a system for attributing value and risk that recognizes the lack of linear cause and effect in these nonlinear parameter cascades. Since we cannot trace an input linearly to an output that's just mathematically impossible, NAT proposes a system for probabilistic and systemic accountability based on contribution and systemic risk.
So we stop trying to pinpoint a single stolen sentence.
Exactly.
Instead, we identify the systemic contribution of a specific data set or a parameter cluster to the final result.
That's the goal. NAT proposes using econometric methods to quantify the statistically significant influence of any protected input data on the model's overall behavior. So if training data set A significantly influenced the overall statistical behavior to an identifiable degree, NAT would attribute value there, even if we can't trace one specific line of code from input A to output Z. It's a method for compensating for systemic contributions in a nonlinear environment.
Finally, we have Theory 5, Synaptic Collective Pattern Rights, or SCR.
This addresses the elephant in the room. AI's ability to extract the distilled essence of human culture. SCR concerns the extraction and manifestation of collective cultural patterns that are embedded in the training data, the synaptic structure. It addresses the fact that the machine has extracted the distilled essence of cultural styles and genre tropes, often from sources that aren't individually copyrightable, but represent massive collective human labor.
Like the statistically derived formula for writing a perfect pulp science fiction novel from the 1950s, or the core visual grammar of 19th century landscape painters.
Precisely. SCR creates rights concerning that extracted collective pattern, which is distinct from the rights attached to any single source work. It acknowledges that value is created by synthesizing patterns that go beyond any individual fixation. This provides a mechanism for compensating or regulating the use of that collective creative capital.
Okay, so to summarize this immense conceptual shift, these 5 theories, probabilistic composition rights, PIR, latent space rights, LSR, constituted parameter rights, CPR, nonlinear attribution theory, NA, and synaptic collective pattern rights, SCR, they reconceptualize AI outputs as lawful manifestations of algorithmic structure. They move the legal focus from the human author to the underlying algorithmic topology.
And the current legal disputes are not just routine disagreements over facts. They are the tangible proof that this theoretical framework is broken. They were the symptoms of the theoretical void we just outlined.
But let's ground these abstract ideas in real-world litigation then. We can start with case 1, Getty Images v. Stability AI. This case involves images. It's very high profile, particularly in the UK High Court.
Right. The essential dispute there is that Getty Images alleges Stability AI used millions of their watermarked copyrighted images to train the AI model.
And the outputs.
The resulting outputs often don't copy the original Getty images directly, but the model clearly learned the underlying style, and in some cases it even regurgitates a blurred, distorted version of the Getty watermark.
So the court is struggling to define copying. If the final image isn't an exact reproduction of a Getty photo, where is the infringement?
That's the classic symptom, and it perfectly illustrates the need for latent space rights, LSR. Courts are struggling to define copying when the alleged reproduction is happening in latent space and not just in the expressive final form. The model has encoded the specific structural geometry of the Getty images within its internal topology. Existing copyright law, which is focused on fixed expression, has no vocabulary for that internal high-dimensional copying.
So, if LSR were law, Getty wouldn't need to prove that the final output image was a copy. They would simply need to prove that Stability AI's model replicated the proprietary latent cluster representing those Getty images.
Exactly. The focus shifts from the output to the structural replication inside the machine. That geometric replication itself would constitute infringement, and that would allow the dispute to be resolved without struggling over the definition of originality in final artifact.
Okay, moving on to text. Case 2, New York Times v. OpenAI in the Southern District of New York. This is a huge one, and critically, it's about the issue of large-scale factual regurgitation.
This high-stakes litigation, it really highlights the immediate need for both probabilistic composition rights, PCR, and synaptic collective pattern rights, SCR. The Times alleges that OpenAI's models scrape their articles for training, and in some cases, the model can generate outputs that regurgitate entire sections of Times articles verbatim or near verbatim when prompted in the right way.
But the larger concern for the Times isn't just that one-to-one regurgitation, it's the model synthesizing their style and factual structure, allowing users to prompt a statistically perfect New York Times article on demand, which completely undercuts their commercial value.
That's the crucial element. The symptom here is the lack of any specialized legal vocabulary for phenomena like probabilistic synthesis and style reconstruction. These things fall short of literal word-for-word copying, but they still destroy the commercial market.
So the model's ability to create their style.
The ability to synthesize their unique journalistic style and probabilistic structure without literal copying demands PCR to regulate the statistical trajectory that leads to that article, and SCR to address the extraction of the collective journalistic pattern of the Times' paid reporting.
So PCR would regulate the likelihood of the model synthesizing a specific article, and SCR would regulate the fact that the model extracted the commercially valuable essence of the journalistic pattern itself.
Correct. The New York Times is arguing about systemic theft of value, but current law only recognizes literal textual theft. This case perfectly demonstrates the breakdown of that distinction.
Let's talk about Case 3, Anderson v. Civility AI in the U.S. District Court. What legal gap did this specific dispute expose?
This case was brought by artists suing over the ingestion of their work for training data, and it really highlighted that critical distinction between works and patterns. The court actually acknowledged that the AI outputs may reflect patterns learned from vast data sets, so the machine clearly extracted cultural value. Yet existing law can only legally recognize fixed human works as the subject of infringement.
So the law sees the fact that the machine has learned and extracted value, but its hands are tied because that extracted pattern isn't a fixed work that can be protected under current definitions.
Exactly right. That conceptual gap demonstrates the absolute necessity of SCR to grant rights over the pattern extraction itself and nonlinear attribution theory, NFT, to deal with the nonlinear way that pattern was formed and how value should be attributed within the model's parameters. We simply cannot regulate the pattern unless we change the definition of what IP can protect.
Finally, let's go to Europe. Case 4, the German music licensing dispute. GEMA v. OpenAI in 2024. It sounds like a real inflection point.
It is a major turning point because it shifts the focus away from the human author entirely. GEMA, which is a powerful European rights society for music, they argued for compensation based explicitly on the statistical reconstruction of musical styles, rather than requiring proof of literal copying of a specific melody or a specific lyrical expression.
Wow, so they're essentially arguing for the enforcement of probabilistic composition rights and synaptic collective pattern rights, even if they aren't using those specific acronyms.
Precisely. They recognize that the commercial infringement is occurring in the statistical synthesis, in the model's ability to perfectly replicate a genre or a style trajectory, not merely in the final melody that it produces. These four disputes, taken together, they confirm that the traditional legal framework is insufficient, and that the time for a first principles framework is long, long past due.
A theory that can't be enforced is just philosophy. We have these 5 theories: PCR, LSR, CPR, NAT, and SCR. The source material claims to have a comprehensive architecture for making these new rights tangible and legally operable. How do you propose to enforce rights that exist in high-dimensional math, not on a piece of paper?
Well, the architecture directly links enforcement back to the technical reality of the models. It moves IP enforcement from what is currently a visual inspection process to an algorithmic auditing process.
Let's start with identification. How do you even know which algorithmic structure belongs to whom?
That starts with model fingerprinting. This involves assigning unique, non-removable identifiers that are linked to the algorithmic structure itself. So, the specific configuration of the billions of parameters and the provenance of the training data. It's essentially a digital chain of custody for the model's topology.
So it's similar to watermarking a document, but you're watermarking the physics, the mathematical DNA of the model itself.
Correct. It allows for clear tracking of a model's origin and its lineage, which is foundational for all the other rights, particularly constitutive parameter rights, CPR. Then, once you can identify a model, you need the tool for verifying latent space infringement. That's latent trajectory audits.
How does an audit of an abstract latent space even work in practice?
These audits are basically technical tools designed to trace and analyze the path an output took through that high-dimensional latent space. For example, if a rights holder suspects latent space replication, the audit tool would be run on the generated output, and it would confirm if the trajectory of that output, the sequence of conceptual steps the AI took, passed through a restricted or proprietary latent cluster.
Like the cluster defining the Getty images style.
Exactly.
So this transforms the abstract concept of latent geometry into a verifiable path for a specialized court to examine. It's like watching a security camera feed of the AI's thought process.
It provides the evidentiary proof that's needed to enforce latent space rights, LSR. Next, for enforcing constitutive parameter rights, CPR, that requires parameter similarity thresholds.
Okay, given that models are continuously being updated and fine-tuned, how can you set a legal threshold for parameter overlap? That seems really tricky.
The threshold is defined based on the proportional overlap or similarity of the foundational parameters between two models that is statistically necessary to replicate the original model's unique topology.
Okay, so if a competing model is found to have, say, 98% parameter similarity with a protected model.
Meaning they essentially copied the core mathematical structure.
Right.
That infringement threshold would trigger CPR, recognizing that the topology shaped by the original R&D effort was stolen. This is designed to stop the creation of near-identical knockoff LLMs.
This seems to be the only practical way to handle direct model theft or these highly derivative competitor models without getting bogged down in just looking at the outputs.
It is a necessity.
Oh, wow.
However, the architecture also includes a necessary communal element, which is really important: public latent zones. These would be legally designated zones of algorithmic space where creativity is considered open, communal, or part of the public domain.
A digital commons for algorithms. This directly addresses that fear of monopoly power, that these new IP definitions will just allow massive tech companies to lock up all mathematical structures.
Absolutely. It ensures that this shift to regulating mathematical topology doesn't inadvertently shrink the creative space or lock up basic human knowledge patterns. Specific styles, simple genre patterns, or fundamental utility code would be designated as free from protection under LSR or SCR.
And finally, to handle these entirely new types of evidence and these new kinds of disputes, the source proposes algorithmic accountability courts.
Right. These would be specialized legal forums designed to handle these probabilistic and parameter-level disputes. A traditional court, which relies on visual inspection of a fixed work, simply wouldn't have the technical expertise. These specialized courts would rely on technical masters and judges trained to interpret complex latent trajectory audits and parameter similarity thresholds.
If we connect this to the bigger picture, this is about ensuring predictability and efficiency in an economy that's increasingly driven by non-human synthetic processes. But let's just solidify the philosophical and economic necessity of this radical departure. I mean, why must we do this?
The source material provides 4 key justifications, and it argues this isn't technological determinism, it's legal survival. First, market failure. Current human-centered laws simply cannot efficiently regulate algorithmic production, and this leads to profound market distortion because creators can't be certain of compensation if a machine can perfectly synthesize their work, and developers can't be certain of legal liability if attribution is impossible.
It creates chaos.
Complete chaos. Second, information asymmetry. The new IP structures, like the latent trajectory audits and model fingerprinting, are needed to reduce the massive gap in knowledge between tech developers who understand the geometry and regulators or individual creators who do not. Transparency requires these new definitions that allow the law to see inside the black box.
The law has to be able to verify claims, and if all the evidence is hidden inside billions of parameters, the law is effectively blind without these new mechanisms.
Third, and this is critical, legal coherence preservation. Existing legal categories are disintegrating under the pressure of LLMs. We're getting contradictory and strained rulings all over the globe. This new framework maintains logical consistency by grounding rights in technical reality, the parameter topology, rather than relying on these increasingly strained and contradictory human analogies.
And the fourth justification.
Democratic transparency. Preserving transparency and fairness in algorithmic societies requires knowing where the legal value and the power actually lie within the AI structure. That value and power, they lie in the parameters and the latent geometry, not in the superficial output. Regulating the source of power is essential for democratic oversight.
The framework seems complete, but it's so radical it invites immediate skepticism. What are some of the preemptive answers the article offers to structural doubts, like the fear that regulating parameters is just going to inherently stifle innovation?
The rebuttal section in the paper is quite strong. For example, regarding the naturalistic fallacy, the idea that what is technical should determine what is law. The rebuttal clarifies that this framework isn't about technical determination, but about legal necessity to maintain coherence and fairness.
And what about the abstraction?
It addresses abstraction criticisms by arguing that while the theories are abstract, the enforcement tools, the audits, the thresholds make them measurable and actionable. And critically, to counter those fears of monopoly power, It proposes that robust system of public latent zones as a deliberate structural countermeasure to preserve the commons and ensure basic utility isn't locked up. The framework is designed to manage the algorithmic ecosystem, not just to privatize it. So what we've really seen today is a massive and I think necessary shift in perspective. We've moved from viewing the AI IP problem as one of just retrofitting old rules onto a new process to understanding it through first principles derived directly from deep learning geometry.
The key takeaway, the central argument here, is that generative AI requires a sui generis IP paradigm because the existing legal categories, they just disintegrate when confronted with the reality of how LLMs work. The true legal battlefield is not the final image or the text.
Yeah.
It's the latent space, the probabilistic trajectory, and the constitutive parameters.
That is where the commercial value actually lies, and so that is where the law must regulate. These 5 emergent theories, PCR, LSR, CPR, NAT, and SCR, they do more than just offer solutions. They provide the conceptual architecture for the next generation of intellectual property law.
So what does this all mean? It means the lawyer of the future. They have to be fluent in deep learning geometry. Legal expertise is no longer sufficient without algorithmic understanding. It means the law is, maybe, finally catching up to the physics of the technology.
And this leads to a final provocative thought for you to consider. If ownership and rights are no longer tied to a fixed work, a tangible book, a fixed artifact, but instead to a dynamic internal mathematical topology, what happens to the concept of the public domain? The public domain relies entirely on fixed works entering the public sphere after their protection expires. If the object of protection is now an internal, ever-evolving algorithmic structure, how do we ensure that cultural knowledge and algorithmic geometry eventually become communal and accessible to everyone? That's something worth mulling over.